Good morning, everybody. It is yet another day, and we are here, Susanna and I, back again. We'd like to welcome you guys to the show. We are the Real HR Show duet. My name is Brenda Neckbottle. I am known as Brenda the HR Lady, and I'm going to flash up how you can find us. And my co-counsel, I've been watching a lot of The Good Wife right now. Is Suzanne Lucas, the evil HR lady.
The difference between us and the good wife is that A, our law will be correct, and B, we wear more clothing.
Everybody wears clothing in that show, but there's some
Not all of the time, Brenda. There's a lot
apparently
of stuff going on.
there's a lot of stuff going on. But there's more clothing on than Game of Thrones. That is for sure. So we are here today to talk to you guys about what are some of the top labor developments that are going on and why you guys should be paying attention to National Labor Relations Board determinations. So just to kick this off, one of the things that is prevalent, and we've got a couple of, kind of high level, this is going to be very high level conversation simply because if we get too deep into the weeds, we'll do a hard left on you guys. But but there's a lot of motion that is going on right now behind the scenes over at the National Labor Relations Board. And I say behind the scenes because this is not something that's usually top of mind. And the reason why we want to make sure that you guys keep this on top of mind and remember is that regardless of whether you have a union or not, your actions are still ruled by the National Labor Relations Board and protected under concerted and protected activities, which basically means this. Concerted really is two or more people. That's the definition loosely of concerted. And protected means that whatever the Labor Relation Board deems as a protected workplace activity means that if it involves more than two people, which is concerted, it therefore becomes protected based off of the NLRB ruling. So that's the short version of it. And probably the most common one that we hear right now, and I'm gonna flip this over to Suzanne as soon as I mention the topic, is why now all of a sudden after many years of saying, well, your pay is considered confidential and you can't talk about it, why, I don't know, for the last 10, at least the very minimum 10 years, now we've had a flip that has said, well, we can't tell people to not talk about their wages.
This seems like it should be something that is so simple to keep going, and yet there are so many companies out there that are absolutely violating this law. And the thing is that culturally we don't talk about pay, and the NLRA doesn't regulate culture. You don't go to the neighborhood block party and say, okay, everybody line up in order of salary. We're going to see top to bottom. Well, that would be fun. But so many companies out there are still doing that, and you just can't do it. And it's something that's fairly easy for employees to prove, because a lot of these people are putting this in their handbooks or sending it via email. And it's not even a squishy area. It's black letter law. You can't prohibit your employees from discussing their salaries. Now that's your employees, your management level people, you can prohibit, but you shouldn't. As soon as you say you can't talk about it, what you're telling them is, I don't think your pay is fair. And so please don't talk about it. And that is just, it's going to get you in trouble, and it's going to get you in a lot of expensive trouble as well. One of my friend's daughters came to me. She's in her early 20s, and her boss told her, no, you can't talk about pay. She's like, I don't think that's right. And her mom sent her to me, and I'm like, no, that's not right. She contacted a lawyer. She couldn't tell me what the settlement was because she signed a non-disclosure. But let's just say, if would have been a lot cheaper for the business that she worked for to give everyone a raise to put them up all at the same level. She was very, very pleased with her settlement. I don't know the exact figure. And it only took a few months to get it all the way through court because the NLRB backs you up. And this is like, this is just so basic. She had a copy of the handbook. The handbook said, don't discuss wages. Here you go. Okay, you've won. It's so hard to defend yourself against because you're in the wrong. I'm a big fan of salary openness in general, too. And that's important.
Well, so Jackson Lewis published an article recently, and this kind of talks about some pretty interesting labor law developments for 2020. And out of the top 5, 4 of them are in relation to the National Labor Relations Board. Now, we're not going to dig into these too deep because, like I said, we'll do a hard left, but we're going to have some comments on these for sure. So the first one is the National Labor Relations Board upheld an administrative law judge's ruling directing an unfair labor practice trial to be conducted by video conference because of the COVID-19 pandemic. So, look, nothing is going to stop when it comes to enforcing the law. And I think that's a big misconception right now is what's going on with COVID, is that I've had a lot of people say, well, there's going to be a lot of leniency. Well, the laws don't change. They don't stop. And matter of fact, probably one of the ones that has been the most flexible by requirement is not necessarily a law, but it's a process, and that is the ability to verify I-9s not in person. You have to verify documents in an I-9 in person, and right now, USCIS is actually waiving that only to redirect it to you can now verify documents virtually. So that's one of the few things.
And that's fantastic. I hope that stays forever.
I don't know if it will, but I do know that it's been extended for another 2 months.
Yeah, I hope it stays forever because in today's day and age of telecommuting will never end, and it makes a lot of sense. But yeah.
So, and then, okay, so that was the first one. Then the second one is that employees laid off due to the COVID-19 pandemic, it was determined that they were not eligible to vote in an NLRB election. The NLRB has held, and that is basically from the Texas Station Gambling Hall and Hotel. And basically what it is that a regional director had ordered an election among laid off employees during a time when the employer had indefinitely suspended its operations due to the COVID pandemic. The NLRB granted the employer's request for review of the regional director's decision and the election, and they found that the regional director erred in ordering an election among employees who have no reasonable expectation of recall. So that clearly is a unionized environment. That's another example. And here's a good one. This one we can sink our teeth into too, for sure. An employer social media rule requiring civility when making public statements about the employer was lawful. The NLRB has ruled, and it's based on the employer's need to protect its reputation, and that is with Bemis Company Incorporated. The employer's social media policy required, in relevant part, employees to be respectful and professional when discussing their employer, and the purpose of the rule was to safeguard reputation and interests of the employer. During an organizing campaign, the union filed an unfair labor practice charge alleging, among other things, that the policy violated the NLRA's by restraining employees' discussions about their working conditions. And found that, so after the ruling, it found that the policy violated the NLRA, but the NLRB was reversed. And the policy was presumptively lawful under the standard of the Boeing case 365. And the reason why is because it held as an objectively reasonable employee would understand the policy was meant to protect the reputation of the company, which is a legitimate purpose under Boeing and not meant to chill the NLRA protected speech. While the NLRB found that the rule could have been written more narrowly to restrict only publicly damaging statements as opposed to private statements made by coworkers, The NLRB found that the possibility of drafting a narrower rule is not a valid basis to invalidate a rule under the Boeing case.
That's a fascinating decision.
Isn't it?
That's a huge flip-flop.
Mm-hmm.
And actually, that's something that you should be aware of as well, is that the NLRB flips and flops a lot based on the membership of the board. And those are political appointees, but they serve 5-year terms. And so you'll have a mix of presidential appointments. And so as the president changes, eventually the board changes as well. So that's an amazing flip-flop,
Yeah.
because they were very much protective previously of people's rights to say whatever they wanted. There was the famous "F.U. Bob" case, which I don't say bad words, so you'll have to look it up yourself, where the NLRB held that that was concerted activity because they had Facebook friends that were coworkers. But this is sounding like it would be an opposite ruling, that you can require them to be civil towards your company. So that's really, really interesting. I would like to learn more about that. I'm gonna have to look that up after we're done.
You want me to send that to you?
Yeah,
No problem. No problem at all.
yeah, that's
So yeah, so that just kind of, that's a good, because social media is a dodgy thing to begin with. I mean, it's a challenging. I mean, every company wants to, actively protect its reputation, and it's a hard thing to do between protecting adhering to what's going on with national labor relations in regards to, not refusing, or how do I want to put it? Employees have the right to voice their concerns on social media as it pertains to the workplace condition. So, for instance, if somebody said, Bob keeps putting his hand on my behind, and he's now done it 6 times, and Bob happens to be the vice president of the company, that's protected.
yes.
And that's an ugly, ugly, ugly thing that there and the employer out there would want something like that to go public, but it's protected. If you know Joanne comes out and says, God, man, Sally Sue just is constantly in my face all day long. She's a wretched coworker, and I'm going to slap the bitch. That's not protected. And in fact, employers have an obligation to actually address that, because that could preclude a workplace violence issue. And not to mention, because it's in a public format like that, depending upon the state that you're in, the employer has some reach of individual liability, but so does the managers, and so does anybody in a leadership or in a position of responsibility in the company of employee welfare. If they see that and they don't report it, they also have individual liability. So if the company doesn't do what they need to do to protect the welfare of the person that's being threatened to get slapped, then the company's got some massive skin in the game. And that is not protected. So you got to really understand what goes on with social media. And
Yeah,
thankfully, it doesn't change as much as it used to.
I think it's really important for companies to have their social media policies written by an attorney
Yep.
and then reviewed regularly, because the NLRB does flip and flop as different things. I mean, one of the things that you don't know that you're voting for this year, but you are voting for it, is the person that's going to choose the next person on the NLRB.
Mhm.
And I don't know when the next person steps down, but it will be within the next 4 years, and several people will. So right now we have a Republican-led board, that can change. And this is not a political show. We're not talking about politics, but you just need to be aware that when you're voting for more than just what's in the news. You're voting for who gets to choose who goes on this board, and that directly affects how you run your business, and what you're going to be held to and what you're going to be held accountable for. And one of the things that has come up recently with the NLRB is discussions of Corona, that you can't tell your employees to not talk about the safety measures that you've taken. And it's very important. And it's also very important for you want them to. If your employees have a concern, you want them to bring it to you. You don't want them to go to a lawyer or go to the media and be like, we ran out of hand sanitizer 2 weeks ago and they haven't replaced it. And suddenly that goes viral on Twitter, or your local news station picks it up. Wouldn't you rather that they come to you and say, hey, we're out of hand sanitizer, and you go, okay, let's get some more? That's just, you want to know these things. Your employees aren't under a legal obligation to tell you first, but you would like them to. And so anytime you try to suppress their speech, it just comes back right behind.
Yeah.
In my humble opinion.
Well, but you're right. I mean, you really have to be careful about what you put out there and what you're not willing to put out there. And some companies will go ahead and make it a policy to not pay attention to employees' social media posts, and I think that's a full-time job right there. I know I wouldn't want to do it, but at the same time, is that when you are made aware of something that is going on with one of your employees or between two of your employees, you have to act on it. Even if you can't see the post, if somebody's reporting it, you got to ask them to show it to you and take a screenshot of it or something. So that way you guys are protecting yourself. You're doing everything you can to not only protect the company, but to protect the employee that the threat was made on.
Absolutely. And like you were saying, Brenda, you don't need to monitor people's social media. Guaranteed somebody does something stupid on social media, their coworkers will bring it to your attention. So
don't worry about that.
And I advise, don't monitor people's social media. Let them have their own life. And I don't care if you're pictured on Facebook drinking on the weekends. Have a good time. There was a big thing earlier. This wasn't an NLRB thing, but where a company was interviewing someone and they slammed her for posting on her Instagram pictures of her in her bathing suit at a pool. And it's like, okay, that's all right. You can wear a swimming suit at a pool. That's not against the rules. But people will bring these things to your attention. So you don't need to go out and monitor people's stuff.
Right.
But when you find out, if you find out something, you find out a threat, if you find out something that is a problem for your business, somebody's violating the law, or, there's so many things that they could be doing. You need to act. You need to act on it.
Yeah.
And you need to take it seriously. And there can be little things like my manager's creeping on my Instagram photos and, making slightly off-color comments. That can be a borderline case depending on what he says. But do you want your managers doing that? And the answer is no. You don't want your managers making slightly creepy comments on their employee Instagram accounts. And you're far better off telling the manager to knock it off than you are to the employee to say, well, maybe if you didn't post those pictures of yourself, you wouldn't say that. That's not what you want to do. You definitely want to say to the manager.
Well, I would be addressing both, because I would also say, well, it's like, it's not just the manager that you invite to make those kinds of comments. It would be other people, but you gotta make choices too.
Yeah, I mean, I'm not saying it's a great idea, but I'm not going to control somebody's Instagram account.
No. They'd
No.
have to pay me a lot of money to do that.
And you know, the other thing that you've got to think about when you're trying to control your employees' speech is that the things that you're trying to hide, the things that you're trying to hide are far more likely to go public when you tell them not to talk about it. Nobody cares about your small business until something goes wrong,
Right.
and then they care. And so if you want to keep those things quiet, the best thing to do is to just let it go. As soon as you tell people you can't talk about this, that's when it's going to come back to you.
Agreed.
When it's going to happen.
And it is. Okay, so here's another example of what's going on with National Labor Relations Board. So their division of advice had issued 5 advice opinions addressing an employer's obligation during the COVID-19 pandemic. So if you guys have questions about this, you need to get with your employment attorney. Not your general counsel, but your employment attorney, because your EAs are the ones that are really paying attention to what's going on. General counsel and corporate counsel, they're really great. They have their place, but your employment attorneys, they are specialists in employment law. So the first of 5 advice opinions came out is that the division of advice found the employer lawfully refused to bargain about paid sick leave and hazard pay because the parties' collective bargaining agreement expressly covered leaves of absence and wage issues and included broad management right language as a zipper clause which permitted the employer to refuse to engage in midterm collective bargaining. So just because you have something that's already in your collective bargaining agreement with what happened with COVID, with bringing emergency paid sick leave and emergency FMLA, doesn't mean that you shouldn't be looking at that stuff. Okay. The next one. The division of advice found the employer did not violate the NLRA by refusing to provide financial information requested by the union about the decision to temporarily close and lay off all staff due to the COVID-19 pandemic. They found that the union was not entitled to the information, including information about government loans and financial assistance, because it was requested for the purpose of challenging the employer's decision to temporarily close the hotel. So again, you guys you really have to dig into the details. What's that phrase? The devil is in the details. Oh, we lost your sound.
Oops, sorry.
There we go. We almost had to do that via interpreted dance.
That's right. That's be more fun. Yes, you got to keep up with those details, and it can be tough. And this is why, like I said, you want your social media policy reviewed regularly. You want your whole handbook reviewed regularly. And you might say that's really a pain in the butt and it's expensive. And why do I do this? The thing is it's going to be so much cheaper to take your handbook to an employment attorney and say, can you review this for me and make any necessary changes, than it is to end up in court or before the NLRB or before the OFCCP or before the EEOC and any other kind of acronym out there.
Or the JUDGE.
What was that?
JUDGE.
I don't know what that one is.
Judge.
Oh, judge. I was trying to figure out what the acronym was.
I had to get one in.
Yeah, it's a lot cheaper because the hour or two that it takes your attorney to review your handbook is going to be less than he charges you to just look at the case that you've now been served. So it's definitely worth your time and money to make sure that you're up to date on all of those things, and don't just review your handbook and then not actually change your practices. Because I see companies doing that too, where their handbook will say you can talk about salary, but then individual managers are saying, shh, don't talk about your salary.
Right.
Or they're not saying it directly. They're just being like, it's not appropriate. But that comes down as a violation right there.
So now, here's another reason why you really want to get your employment counsel involved. Now, granted, this next example is specific to a unionized environment, but this is a really great reason why you have to take a look at everything. So the next one is that the Division of Advice found a unionized employer that laid off employees due to the COVID-19 pandemic did not violate the NLRA when it declined to provide the union with communications between the employer and its clients related to the layoff. The division found that there was no duty to provide the information because it did not relate to the unit employee's terms and conditions of work and thus was not presumptively relevant to bargaining. So again, details are in the devil's in the details. And then we'll do one more here. The Division of Advice recommended dismissal of an unfair labor practice charge, alleging the employer violated the NLRA by laying off an employee for voicing concerns at a group meeting about the lack of hand sanitizer on the worksite. While finding the employee engaged in the NLRA protected concerted activities, there you go, we talked about that just a minute ago, by raising the concern, the Division of Advice found that there was insufficient evidence of the employer's animus towards or knowledge of the protected activity to prove a prima facie case. And prima facie just means on the surface. Like on the surface, it looks like that there was a violation until you actually have to kind of dig into it. So it gets interesting. I mean, and here's the thing is that could some of these things leach into a non-unionized environment? Yeah, absolutely they could. So talking about here, voicing concerns at a group meeting about the lack of hand sanitizer in the workplace. Wow. I mean, that could impact anybody.
That could impact anybody. And that's precisely what will make your employee go viral on Twitter.
Yep.
As well. And some of these things, it doesn't matter what the ultimate ruling of the NLRB is if you've destroyed your reputation. Get the stupid hand sanitizer for your people. Your attempt to save money is just going to cost you. It's going to cost you.
It does.
So, yeah, I think, Brenda, you're really smart to remind people here that we got to think about what's going on with the NLRA and the NLRB and all of those things. The other thing, we're so focused, so many of us are so focused on COVID things that we forget that the rest of these laws exist. Yes. And they didn't go away. They didn't go away at all. They're still there. And those people are still working. So keep your eyes out.
That's right. And the laws haven't relaxed. So this is just a really great example of why you have to stay vigilant, even though you're now dealing with probably about 30% poundage increase of issues just in the current environment. So cool.
Yeah. There you go.
Yeah, I like that. That was good. All right. So you ready? You ready for the questions of the day?
I'm ready. I am ready.
So do you want to go first? Or do you want me to go first?
I'll ask my question first.
Okay.
All right. An employee got into a car accident on the way to work, showed up 2 hours late with a noticeable limp. Can we require she be seen cleared by a physician before working? Should we be concerned that she may claim to be injured at work and file a workers' comp claim?
So that's a complex issue. So first off,
I know that was me.
Great question. It's a really great question, though, because that can happen. This is something that can happen to anybody and has at some point. So if an employee shows up with an injury as a result of an external event, and when the person shows up, people say, "Oh, why are you limping?" And then that person says, "Oh, I got into a car accident on the way in." Simply document that. That's all you need to do. If you have concerns about whether or not that person could turn around and actually file a workers' compensation claim, and they made it public knowledge that it was an external situation, just simply document it. Now, here's the other piece. You also have to take a look at that person's position to determine whether or not that person's the work that that person is required to do could aggravate that injury anymore. If that is the case, then yeah, you could potentially wind up owning the injury. And it depends on how everybody plays their cards, right? So let's say, for example, this person, got into a car accident and they are a sales consultant that works on a retail floor, and they have to physically move. They have to carry things. They're going to be on their feet for an extended period of time. If it was an ankle problem, let's say, for example, they sprained their ankle in a car accident and they decided not to go home, they have to go to work. Could you own that injury? Possibly, because if the person's ankle is already weakened and they trip over something or they resprain it while they're on the work site, then yeah, you should be following workers' compensation. But when you file the claim, you can also state to the claim agent that you're reporting it to that we have knowledge that this person had sprained their ankle earlier in the day on their way to work through a vehicle accident. So we're questioning not the validity of the claim, but we're questioning whether we really truly have skin in this or not. And then, the workers' compensation people will take it through the process. They might even send the employee to, go visit an independent medical examiner. If the person didn't go see a physician and you have concerns that even before they come out onto the floor, that they could potentially hurt themselves more because of the nature of their job, you can just say, hey, you know what, you should probably go get that checked out. And we'll need some documentation from the physician as to whether you can return to work, because this is clearly going to aggravate your situation even more by you being on your feet all day long. And I have a concern about that. So there's a couple things that you can do.
And this is, as you said, something that can happen in any business. This is not unique to any line of business. All of us could get into a car accident or trip or fall or whatever. And we do need to be wary of it. It was a little mean of me to ask something that related with workers' comp, because workers' comp is super complicated and I usually stay away from it.
I've been so involved in it that, I figured out how to kind of like navigate through it pretty quickly, or as best as you can smoothly. And if you have, the best thing to do is that if you have a legitimate concern about the injury, not whether you can see it or not see it, or you think the person's faking it or not, but it's like in this situation, if you're aware that there's an extenuating circumstance that could potentially impact the person's ability to perform the essential functions of the role safely, then you can communicate that to the agents, to whoever your claim agent is, and they'll keep that in mind. And then the process is there for it to work however it's supposed to work. So you're better off letting a workers' compensation process work for you and do its job, because it takes you out of making a determination. And that's some of the things that help protect the company.
Absolutely. There you go. Thank you.
No, thank you. Did I get a gold star?
You get a gold star. You got through a workers' comp question without breaking a sweat, man.
All right. So here's a question for you. Now, and I like to pull these employee viewpoint questions because I like people to know what employees are asking, because I have so many times run into leaders who don't seem to believe that employees think this way. So it's a great reminder that employees think this way. Are you ready?
Nervous? Yes.
You're always nervous when I ask you.
I know, because I feel like I'm on the spot.
You are on the spot.
I know.
I was just on the spot too.
I know, you did great.
No, thank you. You're going to do just fine. Are you ready? So here it is. Is walking out employees at resignation A petty revenge or a justified measure?
Oh, I have strong opinions about this. And my strong opinion that is 99% of the times it's petty.
Okay, well, you got 10 minutes.
I got 10 minutes.
You have
All
10
right,
minutes. I'm
span.
giving you 10 minutes.
Here's the thing. I'm an employee and I hate you as my employer and I want to destroy you. Okay, so that's the underlying assumption. I'm going to do all of that stuff before I tell you I'm quitting. I'm going to download the documents. I'm going to steal the files. I'm going to do all of that stuff before I tell you that I resign. I'm not going to say I resign and now I'm going to go delete all of the code. You know, that's not how it happens. And so when someone is resigning, it's too late. If they're going to be mean and vindictive by the time they resign, it's too late. And most people are resigning because they have a new job or they're moving or something. And they may not love you as an employer, but they're not horrible people. And the problem with treating everybody as if they're horrible is that people start to believe that that's what you think of them. And your remaining employees see this happening. They see that John submitted his resignation and you immediately marched him out. And what ends up happening is, first of all, people stop giving you 2 weeks notice. And you do want that for some positions. You do want a transition time period. And it also makes it very much an us versus them situation. Now, even when you lay someone off, I don't advocate the marching them out. You trusted them 5 minutes before the layoff, and you should trust them now. Now, this does not mean that I don't advocate for telling IT we're going to lay off John at 10 o'clock. At 10:05, please make sure that his email and IT access is changed. You want to make sure that you do that. That's an easy way to get back at people, especially if John controls your social media. You want to make sure that that's taken care of. There's just been some cases in the news of where a sports coach at a university, I don't remember which one, got fired, but they didn't take him off the social media. So that's a bad thing to do. But there's rarely a reason to walk someone out. And there's rarely a reason to hover over someone as they clean out their desk either. If there's someone that you have concerns about, you can treat them differently, of course. But the vast majority of people are good people, and you're just antagonizing your relationship with not only that employee, but all of the others that watch it happening. It becomes the difference between, oh, we're going to miss John, good luck in your new job, to, oh my gosh, what's happening with John? The security guard is standing over him while he packs up his things and marching him out the door. It doesn't build any goodwill. And you want that. There's maybe times when you have an employee quit that you'll want to rehire in 5 years. You've just burned that bridge. We talk a lot about employees burning bridges with their employers, but it works both ways. And it's not even from a company level. It's also you as the manager or as the HR person. You're not going to stay in that job forever. You treat John like crap when he resigns. In 3 years, you may be going on a job interview, and who's sitting on the other side of that desk? Oh, it's John. And you've lost your chance. I'm a huge fan of treating people like adults and dealing with the exceptions as exceptions instead of treating everybody like they're going to set out to destroy your business.
Oh, you did it in under 10 minutes. I'm impressed.
Well, I that's something that I said. I have strong opinions about that, so it's already articulated. I will say, I spent 3 years doing layoffs for a Fortune 100 company, and overall, we laid off probably 3,000 to 4,000 people during that time period. It was pharma, and pharma goes up and down and up and down and up and down. That's just how pharma goes. We had a policy of when we notified people that they were being laid off, we would say to them, today is your last day, and you have the option of going back to your desk now and collecting your stuff, or you can come back in tomorrow. We let them choose. Some people wanted to just get their stuff and go, and some people are like, I want to go home and then come back. And we never, in all of those 4,000 employees, had a problem. Never had a problem. We did have IT shut down their access, but we never had a problem with people taking things they shouldn't take or causing havoc. We allowed people to say goodbye. We never had security. If we were someone we were concerned about, we would have their manager stand by with security notified, but not hovering. And we never ever had a problem in those 4,000 people that I laid off over the years. So if you think there's going to be a big problem, there's probably not. And if there's often a big problem, it's probably your business practices that are causing that problem.
Possibly, yeah.
Not the people. So when someone resigns, I am totally fine with when someone resigns saying, hey, you know what? You need to work out your 2 weeks notice. But if you say that, I also think you should pay them for those 2 weeks.
Yeah, I agree. Cool. Yay. Those are good questions.
Those were good questions.
Those are good questions. Alrighty, so Suzanne and I are both part of we started these and we leaded these. Oh my gosh, we led these groups, we lead these groups. Past tense, future tense, and present tense. That's right. Would you like to share with them about your group?
Absolutely. So Evil HR Lady, you can find us on Facebook. It is a public group, so this is not where you share your personal issues because it's public. But if you have questions about HR or general, you can message one of the moderators and we will post it anonymously for you. If you have a question, you don't mind people know that you're asking it, you can ask it. You can help answer other people's questions. This group is really a positive group and really works well together to help all of us, because a lot of HR people are solo practitioners. It's one HR person in a company, and so this is an area where you can come and get your coworkers, to bounce ideas off of, which is great. And you don't have to be in HR to join. There's a lot of people in there that just find work interesting.
And then I lead the Next Gen Women in HR group. Same principle. We tackle all kinds of HR challenges. We've got a really good group of people that are highly engaged. They're really wonderful people. We have women and men in our group, and all sorts of really good stuff. So that is where you can find us. You can also find us on our social media. I'm going to flash those again. I mean, I just did it a minute ago. I'm going to do it again because I can. So this is how you can follow us. LinkedIn, Facebook, Instagram, Twitter. We got it covered.
We got it covered. We're everywhere.
That's right. So we are really, really glad that you guys joined us. We're going to take time to say thank you very much. And, we drop a new episode every Monday. And looking forward to seeing you guys next week.
Yep. See you next week. And remember to like and share and follow us.
That's right.
There you go. So you don't miss an episode.